Okay.
SJC-11249, E&J Properties versus CBL Realty Trust.
Justice Island.
Hold on. All right, yes.
Justice Island, members of the court. Daniel McDonald, appearing for CBL Realty Trust. This is an action that comes here through the land court that was required to review the 2009 decision of the Fall River Zoning Board of Appeals that arose out of an enforcement action. The 2009 decision of the Zoning Board of Appeals was interpreting its own 2005 variance grant to my client. The issue before the court became whether or not the 2005 zoning variance required as a condition or a restriction the present demolition of a structure on a portion of the property that was subject to the variance. The 2009 zoning decision of the Zoning Board of Appeals in the enforcement action was that there was no time limits set forth in the original 2005 variance requiring that the structures be taken down immediately. The appeals court, in a rescript opinion, has reversed the decision of the land court, ruling that the land court's decision was clearly erroneous, and that in the view of the appeals court, in the context of the matter, it was readily apparent that the 2005 decision intended the demolition of the existing structure to be a condition of the variance. The appeals court did not address the issue of the opinion of the Fall River Zoning Board of Appeals in 2009 interpreting its own 2005 variance. It ignored it entirely. The land court's decision was based on evidence after a hearing, which included, of course, the 2009 decision, the 2005 decision, associated papers, and admissions by the Fall River Zoning Board of Appeals.
Mr. McDonald, accepting your view that there was no time in the decision or in the variance from which the glass something needed to be demolished, is there any limit on that? In other words, can the remainder of the building, which still stood at the time of these proceedings, stay there forever?
I don't believe there's any limit. I believe really, Judge, if you analyze the 2005 variance decision, it permits a city block to be divided into 20 lots. Obviously, an existing building occupies a portion of those 20 lots. If you're going to use the land beneath that building for single-family house lots, then obviously the structure has to come down. I respectfully suggest that's the real thrust of the decision. It's allowing the land beneath the building to be turned into single-family lots. Now, under the Fall River zoning ordinance, this property is in an industrial district. It's surrounded by a variety of mixed uses, including the city incinerator across the street, mills about a block away, multifamily houses, garage. So there are a number of non-single-family uses surrounding this property. Even after the grant of the variance, all right, portions of this lot, even though we're permitted to be used for single-family residences, the variance never said that the only use of that property henceforth had to be single-family residences. So conceptually, any other portion of the city block could be used for industrial purpose in the same manner as where the building presently exists. Even further, the existing building could be taken down. The property is still in an industrial district, and a new, similar building reestablished on the same site without violating the local zoning law.
Because it would still comport with the zoning laws regarding the dimensional laws, those 4 lots
You have
together.
to meet the dimensional
And
requirements.
so the variance had spoke to not only the nature of the use, but also to the variance from dimensional requirements.
That's right.
They were somewhat less than 10,000 square feet.
With reference to the single-family
Right,
residences.
right.
So I respectfully suggest the Zoning Board of Appeals in 2005 was not concerned with time limits. It knew the city, it knew this area, it knew this was an area in transition. It knew it wasn't going to be transformed overnight, all right? It gave permission to use this property for an additional use other than all the uses enumerated in an industrial district.
Did the developer, I guess your client, right, need the variance to demolish?
No, there was no requirement under the zoning ordinance that you had to get a variance to demolish.
And why did they ask for it?
Only because the land beneath, to divide the land beneath the building, all right, which is approximately 20,000 square feet, to divide that into lots, all right, that building would have to be demolished.
So instead of having 20 lots, they have, what, 16? Is that what they
It
have?
would have 16 if you left it out of the formula. Now, having done it that way, you have the future right to remove that building and use that space for lots. So the developer has more alternatives. He can use it for industrial uses or all the uses permitted by the zoning law, and he can use it for the use permitted by the variance. Now, when he does that, it's a function of sort of a lot of different factors, market conditions, economic alternatives, that type of thing. So we respectfully suggest that back in 2005, time limit was not a big concern for the Florida Zoning Board of Appeals. In 2009, when it reviewed the 2005 decision, it found the same thing. It found that there was no condition, all right, that building come down as a part of the grant of the variance. It found that there was no time limits imposed. In the admissions filed in the land court, the Zoning Board of Appeals admitted that it understood that the building would come down when that portion of the lot was going to be redeveloped for single-family uses. Now, the appeals court said the decision of the land court was clearly erroneous, and that it was apparent in the context of the matter that the ZBA intended in 2005 to make the removal of the structure a condition. Well, we respectfully suggest that the local zoning board of appeals has better knowledge of the context, if what is meant by context is the nature of the community, the uses in the community, the rate of growth, the transition period, that the local zoning board of appeals knew better than the court that context. In terms of it being apparent, I don't know how you come to the conclusion that it's apparent. What's only apparent is that that structure has to come down at such time you choose to use the land beneath it for single-family residences. Now, the court cites a couple of cases which says that the Lucier and Di Giovanni, that the variance should be strongly construed against the variance holder. But we respectfully suggest in both of those cases, or in the typical case even, the variance holder and the ZBA have a different interpretation of the variance. In this case, the ZBA and the variance holder both agree as to what the variance meant. So we don't think those cases are particularly opposite to our current situation. The other argument we advance is that this court has a long line of cases suggesting that the local CVA, being part of the community, charged with the task of deciding when variances should be given and when not, that they know better and their decisions should be get deference. For those reasons, Your Honor, we respectfully request that the decision of the appeals court be reversed and the judgment of the land court be affirmed. Thank you.
Good morning, Chief Justice Ireland and Justices of the Court. My name is Mark Bobrowski, and I represent E&J Properties in this case. I'd like to point out a few things about the application, first of all, that was made back in 2005, the original variance here. Both the application and the plan that were submitted, and those are at volume 3 of the appendix at pages 51 and 52, indicate that this is to be demolished. Global Glass is to be demolished, and it's quite clear in the decision as well of the ZBA from 2005 that the building is to be demolished. So there's no surprise here with regard to Global Glass's future. In that regard, I think that this is a lot like the Lucier case that was versus the ZBA of Peabody that this court decided. In that case, there was a reference in the application and in the decision to a 22 by 22 attached garage. Subsequently, the building inspector allowed for an additional floor to be added, which was used as living space, not a garage, and which expanded the footprint or the space of the building to 22 by 26. The court said that that was a condition of the original variance and that a modification was required. In the instant matter, if you look at page 13 of volume 1, it contains the decision, the 2005 decision of the ZBA of Fall River, and it says that the permission is sought to demolish the existing structures and divide the property into 20 lots and construct a single-family dwelling on each lot, not on 16, on each.
Could I ask you this question? Was permission needed from the ZBA to demolish the building?
I don't think so. If they intended to use the property for a compatible industrial use, it was their building, they could demolish it. But when they came...
They didn't, yeah, okay. So
But when they came in and asked for authorization to divide the tract into 20 lots, each, I emphasize, to have a single-family house on it, and indicated on the plans to be demolished, the future of the building is that it comes down and each of the 20 lots will have ultimately a single-family house. Just like in Lucier, the permission was granted for a garage and not for living space.
The same board said, no, that's not what we meant,
I
what you just said.
I agree that the board is entitled to some deference from a reviewing court, but I do not believe that that's abdication. The board's interpretation must be reasonable. It must have a rational basis. I point out that the board's interpretation is not reasonable. It's not reasonable precisely because it never evaluated mixed use on the parcel. Its decision specifically focuses on the impact of 20 houses in the industrial district vis-a-vis the surrounding properties, not the Global Glass building. There was no effort made at the ZBA to evaluate what 16 homes would do or have detriment from Global Glass. In the Mendoza case, that was an important factor that Justice Cordy pointed out. The use of the property for nude dancing was not consistent with the representations that were made at the licensing board hearing. They talked specifically about a bar, a cafe, a place of assembly, and Justice Cordy pointed out that it was never evaluated what the impact would be from the adult use that was proposed for the property. In this case, the ZBA's decision is absolutely silent on whether 16 houses can coexist with Global Glass,
Well,
so it was never evaluated.
Would you agree that if the ZBA, if CBL had demolished the whole building and had kept those 4 lots, if that's what it was going to be, to themselves, they would have absolutely every right to rebuild a Global Glass building, right?
I don't think that the variance authorizes that. If you look closely at it, and it's pretty sparse, so there's not much to evaluate, but if you look closely at it, the passage that I just read...
It's allowed as of right in the district, isn't it?
It is allowed as of right in the district, but the variance now becomes, according to the Medas case, the variance now becomes the law for this piece of property. Medas, the appeals court decision with regard to the scope of property governed by a variance. So if the variance is now the law for this property, you have to demolish the existing structure, divide the property into 20 lots, and construct a single-family dwelling on each lot. That's what the variance says. And I think that the variance also...
Have the right to do that, isn't that what it says?
That's right. And they exercised that right.
Obligation to do
They
that.
exercised the right because they sold 16 lots to my client. And that was under the Cornell case of exercise of the variance here. So the variance has been triggered, and that's the trigger that makes the need for the building to come down. I think...
Wasn't the conveyance of the 16 lots with the reservation of rights with respect to the Global Glass building?
There was an option that was granted, I believe the record will show, to my client to purchase the Global Glass building, but I don't know that I would construe it as a reservation of rights. What I think is that in this case, the client obviously was induced to purchase the 16 lots with the expectation that the Global Glass building would ultimately come down. As he's inching closer and closer, he started at the far end of a very rectangular piece of property. As he inches closer and closer, the Global Glass building becomes that much of a negative factor in his marketing ability.
But Judge Twombly finds that the deed to E&J Properties indicates that the conveyance of the lots is, quote, subject to the right of CBL Realty to maintain the existing encroachment of the Global Glass building upon Lot 20.
I'd have to review that, Your Honor. That's not clear to me. The other aspect of this that I think gets buried is Section 10 itself says that conditions can be imposed in a variance, including the continued existence of any particular structure. The only reference in the record here is that this particular structure is to be demolished. So if that's ambiguous, and I guess for purposes of argument I'll agree, then the language from Mendoza and Lucier should take control, which says precisely that ambiguity is resolved against the holder of the variance. In that regard, I think the Fall River ZBA was wrong as well. If you resolve this ambiguity against the holder of the variance, then the building has to be demolished. That's the simple outcome here that the result in both Mendoza.
That's converting language of permission to demolish into requirement to demolish, isn't it?
In my opinion, the 2005 variance was predicated upon demolition of the Global Glass building and the development thereafter of a 20-lot subdivision. That's what it says. It says each lot will have a single-family home. It does not take into account continued existence of Global Glass in any way, shape, or form. There was no measure of detriment that would impact the buyers of these 16 homes, and I think in particular they would be the ones most concerned. If you're buying into a residential subdivision and it's going to have a continued industrial facility on it, that's a big difference than buying into a neighborhood of 20 homes.
So why isn't the flaw in the contract that your client signed as opposed to in the variance?
The variance would be the controlling factor here with regard to the municipal impacts on the city of Fall River. Certainly the contract can't obviate the variance. The variance would control.
The contract could have provided that it's a condition of the contract that they demolish the entire premises, and apparently it did not.
Well, I think in the original inception of this case, it was the building department's own motion that issued the cease and desist order. It wasn't upon...
Saying that your clients didn't ask for that?
The building inspector took this action on his own, and the Board of Appeals reversed the building inspector. And the land court ruled for the Board of Appeals. The appeals court affirmed the building inspector's original decision, which I think was correct.
Do any of the, or does the zoning ordinance for the city permit a residential use in an industrial district?
No, not a single-family home.
Okay.
So the sale under the Cornell case would trigger or exercise the variance, and then the terms and conditions of the variance would apply to the entire property. And as I keep pointing out on page 13 of the volume 1, the original 2005 ZBA decision does not contemplate the continued existence of Global Glass. It calls for a single-family home on each of the 20 lots. Anything in the contract between my client And Mr. McDonald's client is a
so you
subsidiary
think-
or
you think-
subservient to the variance itself.
So if the standard is it was, you know, arbitrary, whimsical, da-da-da-da-da, you say it's all of those things, the decision of the ZBA?
I think it was an abuse of authority, arbitrary, capricious. Those are the boilerplate terms that are in Section 17, which I'll repeat here for purposes today.
All right, counsel, thank
Thank
you
you.
very much.